record in the People of the State of Michigan versus Lewis Edward Thurston, file 22-21160-FH. Today's date set for a pretrial conference in this matter. We are proceeding today by partially by video conference and partially in person. First, may I have the attorneys place their appearances on the record.
D.B. Mayor on behalf of the people.
Matthew Murphy, appearing on behalf of Mr. Thurston.
And sir, you are Lewis Edward Thurston?
Yes.
And Mr. Thurston is here in person. Mr. Murphy, where do we stand with Mr. Thurston's case today?
Your Honor, at this time, in speaking with the prosecutor, Ms. Wagner, in regards to this matter, the prosecution was willing to offer for Mr. Thurston to plead as charged to the OWI felony with an agreement to cap his initial jail sentence at 30 days or less. So that's what Mr. Thurston does want, to plead guilty as charged to the file. Again, with the agreement from the prosecution that his initial jail time would be no more than 30 days.
All right, Ms. Muir, is that a complete and accurate statement of the agreement?
Yes, Your Honor.
Okay, and how about the habitual offenders, that being dismissed?
That'll be dismissed, Your Honor. I'm sorry.
Yes, Your Honor.
Okay. Mr. Thurston, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, I do.
And you are Lewis Edward Thurston, correct?
Yes.
Mr. Thurston, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to operating while intoxicated, third offense?
Yes.
Are you satisfied with your attorney and the advice that he's given you?
Yes.
Do you understand that the maximum penalty for that offense is up to $5,000 fine and either 1 to 5 years in prison or probation with 30 days to 1 year in jail?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed possible sentence with the court other than as we've discussed it on the record here this morning. Is that correct, Ms. Muir?
Yes.
That's correct.
Mr. Murphy,
Yes, Your Honor.
is that also your understanding, Mr. Thurston?
Yes.
If guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at your trial, and have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes.
You also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. You understand all of those rights?
Yes, I do.
You have any questions about any of those rights?
No.
You understand you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about July 7, 2022, in the city of Tecumseh, County of Lenawee, that you did commit the offense of operating while intoxicated, third offense?
Yes.
You would need to say guilty if you want to plead.
already done that, right?
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
You understand that if I accept your plea, you will be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter the plea.
Yes.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Thurston to plead guilty?
None, Your Honor.
No, Your Honor.
Mr. Thurston, other than as we've discussed here this morning, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty?
Yes.
Mr. Murphy, do you wish to establish a factual basis?
I will, Your Honor. Thank you. Mr. Thurston, were you indeed in the city of Tecumseh the County of Lenawee, State of Michigan on July 7th last year, 2022?
Yes,
And on that date, were you operating a motor vehicle on a public highway?
yes, I was.
Was that Cummings Highway or Cummings Street?
Yes,
Okay, were you operating a moped, is that correct?
yes, I was.
Okay, and while you're operating that moped on that public highway, would you agree that your blood alcohol content was a 0.08 grams per 210 milliliter or liters of breath or greater?
Yes,
You actually came in contact with the police on that day, correct?
yes, I did.
And they did a breathalyzer, a PBT, and a data master, correct?
Yes,
Okay, do you recall the results of those?
no, I know.
Okay,
I
would you
failed.
agree though that they were a 0.10 and a 0.11?
I'm not sure what they were, but I know I failed the test.
So you know that the test results were that it was over a 0.08, correct?
Yes,
Okay, and did you indeed have prior operating while intoxicated offenses?
yes, I did.
Okay, have you had one, let me see here, how many prior offenses have you had?
I have no, I'm not sure.
Okay, would you agree though that you had at least 2 prior OWIs, operating while intoxicated?
Yes,
Okay, Your Honor, I'm satisfied with the factual basis, I guess.
Just for
All
those
right.
priors, do you agree that there was one October 19th, 1992 in Van Buren County?
yes, I do.
And that there was also an operating while intoxicated conviction on April 16th, 2012 in Washtenaw County?
I can't really remember the dates, but I know I did get busted in Washtenaw County.
I'm just asking if you agree with that date, not if you remember that date.
Yes,
Okay, I'm satisfied with the factual basis, Your Honor.
Thank you.
Okay, has court complied with MCR 6.302 B, C, and D, Ms. Muir?
It has.
Mr. Murphy?
Yes, Your Honor.
All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Thurston has had full knowledge of his rights and he has had competent counsel. The court's not made any agreement other than as we placed on the record this morning regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 1st at 8:15 a.m.
Your Honor, may we address bond conditions briefly?
One moment, Mr. Thurston, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
yeah, I will.
All right,
Judge?
Mr.
Actually,
I'm sorry.
we need him to go right over to our office and check in and get paperwork.
Okay, so as soon as you're done here, you need to step across the hall to the probation department. They will have some paperwork for you.
Okay.
All right, Mr. Murphy, what is it you wish to say about bond?
Your Honor, in regards to the bond conditions, we had addressed this previously. I don't know if Your Honor recalls, but Mr. Thurston had issues with going and getting and doing the actual PBT. So he got himself on a home unit and he's on a scram unit. Now, in regards to Mr. Thurston's case, we were trying to figure out if there was available counseling for him to attend in Tecumseh as part of one of the plea agreements with the offer or one of the offers from the prosecution. But Mr. Thurston does have limited mobility. He doesn't have really transportation. He doesn't have anyone that could provide transportation to him. So that was something that he wasn't able to find there in Tecumseh area. Now, I'm asking if the court would consider, based upon the length of this case, I mean, it isn't super long, but it was started back in November. He has been on bond conditions since then. There was an issue at the very beginning that was dealt with. For the past 5 months or so, there hasn't been any issues with him on his bond conditions. He hasn't failed any of the tests. I'd ask the court to consider reducing or removing the bond conditions. I'd actually ask the court to consider removing them, I guess, for the testing and just having it on regular and random maybe. I do believe he has stopped drinking since the pending of this case, since the incident had occurred. So I do believe that he would continue to do so without the need to have the consistent testing. So that's going to consider that at this time.
Ms. Muir, anything you'd like to say?
Or I'd just defer to the court. I think as long as he's on some sort of alcohol conditions, it'd be appropriate, but I defer to the court as to what those would be.
So it was just at his last pretrial that we changed from a scram unit to the home alcohol testing. I think, this case looks to me like, unfortunately, Mr. Thurston has a serious problem with alcohol. This is a third offense of DUI. I think that closer monitoring is appropriate through at least the sentencing date, and then the probation department can determine what is appropriate from there. So I'm going to decline to further modify the bond conditions at this point, and we will address those through this probation term at sentencing.
Yes, Your Honor. Thank you.
Your Honor, I ain't really got no problem with doing the test twice a day. The only problem I'm having is paying for it. Yeah, I only get $800 a month to live on. And, it doesn't go very far. And having to pay $100 and almost $200 a month for that thing is killing me. I can't even use my heat because I can't afford to use it.
Mr. Thurston, I understand that it's a financial difficulty for you, but I also, part of my job is to
I realize I've had a few instances of, drinking and driving, but look how far apart these are. It's not like, I'm not out trying to kill anybody or nothing. I have a drink now and then.
a few people that engage in the behavior that you engage in are out trying to kill someone, but a lot of people unfortunately do. So that's my concern.
Well, I don't even
clearly
have a
have Mr.
vehicle
Thurston.
now.
Mr. Thurston, I've made my decision and I'm not going to change my decision. I understand that it's a financial difficulty for you, but I also have an obligation to make sure that people comply with their bond conditions. And this is what I believe is required to satisfy that at this point. And we can readdress that issue at your sentencing hearing when you'll likely be placed on probation. Mr. Malero, are you ready to proceed with Mr. Height?
I am, Your Honor.
All right, we're on the record in the People's State of Michigan versus William Isaiah Height, file 22-21157-FH. This is set for a pretrial conference this morning. We are proceeding today by video conference. First, can I have the attorneys place their appearances on record? Ms. Muir, is this your case? Oh, I'm sorry. This was the we have the Hillsdale County prosecutor serving as special prosecutor in this case. I believe that's Ms. Wisniewski.
Yes, Your Honor. Good morning. Jamie Wisniewski on behalf of the.
Salvatore Malero on behalf of William Height.
All right, and Mr. Malero, where do we stand with Mr. Height's case today?
And I've spoken to the prosecutor on this matter in an effort to resolve it. I think we are very close to resolution. I would ask the court if we could have a brief adjournment, even a week, so I could go meet with Mr. Height, explain all this to him, make sure he understands it, and then I think we could be able in a position to put a plea on.
So next week would be April 26th. So we can set for April 26th at 8:15 a.m.
That'd be perfect, Judge.
That's fine, Your Honor.
Oh, thank you. Mr. Malero, would you do a stipulation in order for that adjournment, please?
I will, Your Honor. And William, I'll be over tomorrow or Friday, and we'll go through this, okay?
All right, Mr. Height, you can let the officer that's with you know that you are done with court for today.
Get close.
Thank you, Ms. Wisniewski.
Thank you. Have a good day.
Jesse Rodriguez instead of turning.
Thank you.
Okay, Mr. Malero, Caden Weir is logged in. Do you need a breakout session with him? Sir Malero, are you there?
Yeah, real quick, Judge, won't take long.
Wait 1 second.
Sorry.
All right, Mr. Weir, are you able to hear me?
Yes.
Okay, I'm going to place you in a breakout session with your attorney.
Okay, thank you.
When you just Good morning, sir. You're Mr. Rodriguez.
Yes, sir, Your Honor.
Mr. Dagger Margosian, do you need a breakout session with Mr. Rodriguez?
Yes, please, Your Honor.
Morning, sir.
Well, Stephanie. Okay, Ms. Underwood, I believe we're ready to proceed with Mr. Watson.
Thank you, Your Honor.
It's 22-50137 PP. Thank you. Right.
Gonna do Watson. All right, we're on the record now, again, in People versus Philip Matthew Watson, file 23-21279-FH. I do have the amended information at this point. And it's my understanding again that Mr. Watson will be pleading to count 2 on the amended information, attempted assault of a prison employee. Is that accurate?
That is accurate, Your Honor.
All right, Mr. Watson, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
And you are Philip Matthew Watson?
Yes.
Mr. Watson, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 attempted assault of a prison employee?
Yes.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes.
Do you understand that the maximum penalty for that offense is up to 2.5 years in prison and/or $1,250 fine?
Yes.
Neither the prosecutor, defendant, nor anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed it here this morning. Is that correct?
Correct.
Yes.
Your Honor, I believe we need to put the cops on the record.
Thank you. I believe you're right. I don't think we've done that yet. So Ms. Underwood, if you would like to place your understanding of that agreement on the record, you can do that.
Thank you. My understanding, Mr. Watson, is that the judge and I have had a discussion and he's agreed to COBS this matter to the low end of the guidelines or 12 months as your minimum, whichever is lower.
Okay.
All right. Do you understand that, Mr. Watson?
Yes.
And do you still want to proceed with entering your plea?
Guilty.
I'm sorry, was that a yes?
Yes.
Okay. If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial, and explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty, and you do not have to prove anything. You have the right to be present at your trial, have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court ordering the witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Watson, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes.
You also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right.
Yes.
If you are not a citizen of the United States of America, a conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights, Mr. Watson?
No.
Do you understand that you're giving those rights up?
Yes.
How do you wish to plead to the charge that on or about September 15, 2022 in Madison Township, Lenawee County, Michigan, that you did commit the offense of attempted assault of a prison employee?
Guilty.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record here this morning, or that it was not your own choice to enter that plea?
Yes.
Is prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Watson to plead guilty?
No, Your Honor.
Mr. Watson, has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record here this morning?
Pardon me?
Has your attorney promised you any particular sentence or estimated what your sentence would be other than as we've discussed it on the record here this morning?
No.
Is it your own choice to plead guilty?
Yes.
Ms. Underwood, do you care to establish the factual basis?
Yes, Your Honor. Thank you. Mr. Watson. Did you, I believe the date, Your Honor, may be incorrect. Hang on a minute. Just let me double check that on the information.
The correct date is July 24, 2022.
Yes, yes, Your Honor. Mr. Watson, on July 24th, 2022, were you an inmate at the Gus Harrison Correctional Facility located in Madison Township, County of Lenawee, State of Michigan?
Yes.
And did you come into contact with an employee of the Gus Harrison facility, Tyler Bell, Corrections Officer Tyler Bell?
Yes.
And he was employed at the Gus Harrison facility, and you came into contact with him during the course of his employment?
Yes.
And at that time, did you assault Mr. Bell by spitting on his arm?
Yes.
And you knew that that was not, you knew that he did not give you permission to spit on his arm, and you knew that that was an assault, correct?
Yes.
I believe I've established the factual basis, Your Honor.
Ms. Mayor?
I'm satisfied, Your Honor.
All right, has the court complied with MTR 6.302 B, C, and D, Ms. Mayor?
It has.
It has, Your Honor.
All right. I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Watson has had full knowledge of his rights and he has had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation, and we will set sentencing for June 1st at 8:15 a.m.
What was that date, Your Honor?
June 1st at 8:15.
Thank you, Your Honor.
And then is a Zoom writ acceptable, or do you want to be in person?
Okay, Mr. Watson, you have a right to be present in person for your sentencing hearing. If you prefer to do it by Zoom, you would need to waive your right to be here in person, and we could have you attend by Zoom. Do you know what you would like to do in that regard? I'm sorry, your voice didn't get caught on the microphone. Could you say that again?
Waive my right?
Okay, so you'd like to appear by Zoom?
Yeah.
Okay, so a Zoom writ sounds like it will be sufficient then.
Thank you, Your Honor.
Mr. Watson, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes.
Okay, thank you. You are all set then. You can let the officer that's with you know that you're done with court for today.
I'm done.
Yes.
Thank you.
Mr. Dagger Margosian, are you ready to proceed with Mr. Rodriguez?
Yes, Your Honor, assuming, well, we had asked for an amended information to be submitted, so if the court has that, we can proceed.
I do have that.
Okay.
Okay, we are on the record in the People of the State of Michigan versus Jesse Abel Rodriguez. It is file 23-21301-FH. Today's date set for, I believe this is an arraignment. No, this is a pretrial hearing. Set for a pretrial hearing this morning. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record.
Be Mayor on behalf of the people.
Your Honor, Michael Dagger-Margosian for Mr. Rodriguez.
All right, and Mr. Rodriguez, where do we stand with Mr. Dagger-Margosian, where do we stand with Mr. Rodriguez's case today?
Your Honor, we are in a position to enter the plea to the added count of possession of controlled substance. We had tried to enter this plea 2 weeks ago, but unfortunately the court didn't have time. So but again, we are ready to proceed today. And just
Go ahead.
Just to complete the plea deal, it will be pleading guilty to one count of controlled substance possession, and in exchange for that, it will be dismissal of the original counts of counts 1 and 2, as well as any supplemental attachments.
Okay. Ms. Muir, is that an accurate statement of the plea agreement?
It is, Your Honor. The only other thing we discussed was that after the plea, or I'm sorry, after the sentence, Mr. Rodriguez would be released from Lenawee County Jail and likely transported to Ohio, I think, for something he has pending there.
If we could address that now, so it seems as though there's not a holder in Ohio. Mr. Rodriguez, I believe, is on probation, but I don't believe that there is a holder or violation. Obviously, he's going to have to contact his probation officer in Ohio, but I was going to ask the court after the plea to consider releasing him today.
Well, let's take care of the plea first. Mr. Rodriguez, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir, Your Honor.
You are Jesse Abel Rodriguez.
Yeah, I raised my hand still, sir. Yes, sir.
You can put your hand down. So I'm sorry, you are Jesse Abel Rodriguez, correct?
Yes, sir.
You've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 3, possession of controlled substance, cocaine, heroin, or another narcotic less than 25 grams?
Yes, sir.
Do you understand the maximum penalty for that offense up to 4 years in prison and or a $25,000 fine?
Yes, sir.
Are you satisfied with Mr. Dagger-Margosian and the advice he's given you?
Yes, sir, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Muir?
That's correct.
Mr. Dagger-Margosian?
Correct, Your Honor.
Is that also your understanding, Mr. Rodriguez?
Yes, sir, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you're guilty. You do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Rodriguez, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yes, sir, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, sir.
Do you understand you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about March 11, 2021, in the village of Clayton, Lenawee County, Michigan, that you did commit the offense of possession of cocaine, heroin, or another narcotic less than 25 grams?
I wish to plead guilty, Your Honor.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir, Your Honor.
Do Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to court on the record here this morning, or that it was not your own choice to enter the plea?
Yes, sir, Your Honor.
Is prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Rodriguez to plead guilty?
No, Your Honor.
None, Your Honor.
Mr. Rodriguez, has your attorney promised you any particular sentence or estimated what your sentence would be?
He read me my guidelines, Your Honor. That's it.
Okay, do you understand that regardless of any conversations that you've had with him regarding the guidelines, that ultimately it's my decision on what your sentence would be?
Yes, sir, Your Honor.
Do you understand that it's possible that that might be something different than what you've discussed with Mr. Dagger-Margosian?
Yes, sir, Your Honor.
And do you still wish to proceed with entering your plea?
Yes, sir, Your Honor.
Okay. Is it your own choice to plead guilty today?
Yes, sir, Your Honor.
All right, Mr. Dagger-Margosian, do you care to establish factual basis?
Mr. Rodriguez, as the court indicated, on March 11th of 2021, were you in the village of Clayton and in County of Lenawee, state of Michigan?
Yes, sir, Your Honor.
And on that date, were you in possession of a controlled substance?
Yes, sir.
Okay. And you didn't have a legal right to possess that substance?
No, sir.
And you knew that that substance was illegal?
Yes, sir.
Okay, I think I'm satisfied, Your Honor.
Was it less than 25 grams?
Yes, ma'am.
Okay, and just for purposes of the plea, it was methamphetamine, but we're entering this plea under the lesser offense of cocaine or another narcotic.
Yes, ma'am.
I'm satisfied with the factual basis.
Has the court complied with MCR 6.302 B, C, and D, Ms. Muir?
It has.
Yes,
Mr.
sir.
Dagger-Margosian? All right, I'll accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Rodriguez has had full knowledge of his rights. He's had competent counsel. The court's not made any agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 2nd at 8:15 a.m. Mr. Rodriguez, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Yes, sir, Your Honor.
Mr. Dagger-Margosian, you wanted to address bond.
Your Honor, I'm asking you to release Mr. Rodriguez on a personal recognizance bond for the following reasons. He's been in custody for well over a month at this point. It may be closer to 2 months. I spoke with his fiance yesterday. She confirmed that he will be, returning to their address in Morenci. She works at Subway. He's planning on working there as well. There is this matter of if he has something pending in Ohio. Again, what I can relay to the court is that he is on Ohio probation, but on good faith and information, I don't believe that he has a warrant on that particular case. Now, he may have an active warrant for some sort of child support issue. And if that's the case, then he obviously will be advised to, if he's released, he'll be advised to walk in on that warrant in Ohio. But for purposes of this case, I think it would be appropriate to release Mr. Rodriguez. Obviously, he has taken responsibility today, and the guidelines that he had alluded to, while they're informal at this point, I have scored them at 0 to 11. So assuming that it's somewhere in that range, I don't suspect that he's going to get any further incarceration on this case.
Ms. Muir, anything you'd like to say on the issue?
Just that I did relay to Mr. Dagger-Margosian, and he kind of alluded to it, that there was a prosecutor from Fulton County who reached out to check if Mr. Rodriguez was in our jail still, because she does have an active child support warrant out for him. Whether it's a pickup warrant or not, I didn't get those details, but you know, as the court's aware, we have run into issues before where someone gets transferred and then we can't locate them for sentencing or subsequent hearings. That being said, if it's not a pickup, then it would be on Mr. Rodriguez to get himself back here for sentencing. So I'll leave it in the discretion of the court.
May I address the court, Your Honor?
Mr. Dagger-Margosi, do you want Mr. Rodriguez to speak directly?
I may, but I don't know what it's pertaining to. Could I have just literally a 10-second breakout with him?
All right, I'm going to grant the PR bond anyway,
That's fine.
so it's probably not an issue.
All right, then no say that. I have nothing left to say then, Your Honor.
Okay, I think under the circumstances, I am comfortable that, well, first we have plea entered and that we will be able to locate Mr. Rodriguez if he's arrested on the warrant that is outstanding. So we know it's in Fulton County, so Ohio. And I think that we'd be able to arrange a Zoom session with them. So I think I'm all right. I'm going to issue PR bond, and that will include requirements that you, Mr. Rodriguez, report to Lenawee County Pretrial Services, Darren Coast, as required by Mr. Coast, that you not use alcohol, marijuana, or any illegal controlled substances, that you participate in the substance abuse monitoring program, so drug testing as directed by Mr. Coast.
Yes, sir.
And obviously that you appear for all court hearings.
I have received his paperwork already, Your Honor.
All right, so what I'm going to do is
Judge, I need his address.
Yeah, I'm going to place in a breakout session with Ms. Walsh from the probation department right now so that you can give her the address in Morenci where you're going to be living.
Judge, I do want to put on the record, when he's released, he should go immediately to our office as well. Mr. Rodriguez, did you hear me?
Yes, ma'am.
Yep, so as soon as you get out of jail, come over to the courthouse, third floor, go to the probation office and check in with them. They'll have some paperwork for you.
Okay.
Is this are you Miss Burns?
Yes.
You come forward to the podium, please. No. Mr. Ianni, are you here for child support cases?
I'm here for the Trenton Greenblaker case.
Okay. Can you call for what Trenton? All right, I'm sorry, Ms. Burns, I lost the public defender that
Thank you.
is representing you, so
My last name is Spresser.
I'm sorry.
My last name is Spresser. That's my maiden name, and I was supposed to have Matt Murphy.
Mr. Murphy,
Yeah,
I'm sorry, can you spell your last name for me?
Spresser.
Okay. Mr. Murphy, Ms. Spresser is here.
Your Honor, it's currently assigned to Miss Underwood. I wasn't sure what we're doing, if it's being transferred or not today, so I had nothing about me covering it. I wasn't sure what Miss Underwood wanted to do with the case today, so it's best if we wait for her for today, I think. And then moving forward, if it gets transferred to me, obviously, I'll speak with Ms. Spresser about it. But as it is right now, it's Miss Underwood's case.
All right. So Ms. Spresser, then I'll have to ask you to sit back in the gallery, and as soon as Ms. Underwood gets logged back in, I'll have you speak with her.
Okay.
Yes, sir.
Mr. Malero, are you ready to proceed with Mr. Weir?
I am, Your Honor.
Okay, we are on the record in People of the State of Michigan versus Caden William Weir, file 22-21083-FH and 22-21084-FH. These are both set for pretrial conferences this morning, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
EB, Mayor, on behalf of the people.
Salvatore Malero on behalf of Caden Weir.
All right, and Mr. Malero, where do we stand with Mr. Weir's cases today?
Your Honor, I'm going to ask the court to adjourn this one further time. I think that Mr. Weir has to give me some documentation. I'll provide that to Mr. Hartung, and I think at that point we'll be at a point of resolution. So that'd be my request. I would think somewhere in the neighborhood of perhaps 30 days should suffice.
Okay, Ms. Meir, anything to add from the people's side?
No, Your Honor.
Okay, I will adjourn this then to May 24th at 8:15. Just looking at these files, unless there's a pretty good reason, that's going to be the last adjournment. They were bound over, looks like back in September of 22. So we need to get these resolved one way or the other.
Correct. Thank you, Judge.
Mr. Malero, would you do that stip in order for the adjournment?
I will.
Okay. All right, Mr. Weir, you can go ahead and log out.
Your Honor, I heard from Ms. Underwood. I can handle Ms. Spresser this morning if we're ready to go for that one.
Okay, do you want a breakout session with her?
Your Honor, I recall speaking with Ms. Spresser about this incident previously. I think at this point, I'm ready to proceed on the record unless she wanted to talk with me in a breakout.
Ms. Spresser?
No, it's fine.
Okay. All right, if you'll come back up to the podium, then Ms. Yes. All right, we are on the record in file 22-50137-PP, Chad Palms versus Sarah Burns, now known as Sarah Spresser, S-P-R-E-S-S-E-R. We are here today for a hearing on a PPO, personal protection order violation. We are proceeding today partially in person, partially by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Meir.
Your Honor, Phoebe Meir, on behalf of the petitioner.
Matthew Murphy appearing on behalf of Ms. Spresser.
Okay, so Ms. Spresser has previously been, I believe, arraigned on this case and had the public defender's office appointed for her. Mr. Murphy, do you know how she would like to proceed with this alleged violation today?
Your Honor, at this time, I think we're asked to set a hearing in this matter I'll just ask if we could set it, excuse me, maybe, I guess, whatever fit the court's schedule, but I'd ask for maybe at least a month or so, to talk with the prosecution, and if there is a resolution short of having the full hearing, then obviously we'll notify the court. But I think, from my understanding of this allegation, and from speaking with Ms. Spresser previously, I think that would be the best option right now, will be to again ask for to schedule a full hearing and just see if we can figure something out before that time.
All right, so if this goes, how long do you think we're gonna need? Is an hour sufficient, or do we need more than that?
Your Honor, I think an hour would be sufficient, but obviously since it would be the prosecution calling and, the witnesses, I think I'd defer to them, but I think an hour would probably be sufficient.
I would agree, Your Honor.
All right, Ms. Mayor, I have Mr. Palms in the courtroom, and he's indicating that he'd like to say something. Do you want me to set up the iPad so you can speak to him?
No, he can come up to our office and speak with victims' rights.
All right. Okay, Ms. Andrews, can you find us a 1 hour hearing time, please? About 30 days out.
I have, if we want to do it on a Friday, I could set it as a backup. At 9 o'clock
On what date?
on May 26th, I'm sorry.
That'll be fine for the defense.
That works, Your Honor.
May 26th at 9 a.m. All right, so we'll set it for May 26th at 9 a.m. The court will send out a notice for that hearing date. Mr. Palms, again, if there's something that you want to communicate to the victims' rights, they'll get it to the prosecutors, and that then it will come to me, and that's the appropriate process for that to happen. Okay.
Thank
All
you.
right. Thank you, then, Ms. Spresser. You are free to leave. Then next date's May 26th at 9 a.m.
Ms. Spresser, my office will contact you about making an appointment to come in, okay?
All right, thank you.
Yep. Thank you, Your Honor.
Okay, the gentleman at the jail, you are Mr. Greenblaker.
Yes, Your Honor.
Mr. Murphy, do you need a breakout session with Mr. Greenblaker?
Yes, please, Your Honor.
All right, I've got a second room at the jail, Lenawee County Jail, room 3. The camera's off, the microphone's muted. If there's anyone in that room, can you unmute and tell me who you are, please? Can you call and see if they do have that room available for us? Can you ask for Malik Owens? Ms. Muir, I've got a question for you on Janice Gout versus Michael Lambert that was on our docket for today. The documents that were filed in that case have different parties. The defendant is listed as a Nicholas Williams, but it has this case number, and I believe it has Ms. Gout as the petitioner.
Do you know if it's a file A or a file B?
So,
Or just in a regular file? Because there's a first violation or a PPO, and then there's an A and a B file.
all right, so the file number that's on this, on the violation that, or the order to show cause that I'm looking at is an A. So it's 2249696 PPA.
Okay.
But it lists Janice Lynn Gold, but so the name was not correctly spelled, versus Nicholas Ryan Williams, but that is not the respondent in this case.
Yeah. I can look into it. I don't even see a PPO in our file on that one.
Okay.
So do you have a copy of the PPO?
I can email you what I've got.
Well, I'm wondering if it didn't just get submitted under the wrong name. Because the complaint that goes along with this police report is a felony charge for a CSC. So there might be something messed up in our file and it got authorized under the wrong name.
Okay.
I can look into it. It just won't be this morning necessarily. By the time I figure it out, I'm sure.
That's okay. There's no, there doesn't look to be any service of it in the file, so we wouldn't
Okay,
be
that's
doing
probably
anything.
a good thing in case it is the wrong people, so. Okay, I'll make a note and look into it after this morning.
Okay, so I just sent you a copy of the order to show cause and the petition that was scanned into the computer system.
Okay.
Mr. Murphy, are we ready to proceed with Mr. Greenblaker?
Yes, Your Honor.
All right, we are on the record then in People of the State of Michigan versus Trenton Jonathan Greenblaker, file 22-21192-FH, file 20-20114-FH, and file 23-21192-FH. 274-FH. These are all set for pretrial hearings this morning. We are proceeding today by video conference. First, can I ask the attorneys to place their appearances on the record, beginning with Mr. Ianni?
Special Assistant Attorney General Robert Ianni for the people, Your Honor.
Your Honor, Phoebe Meir, on behalf of the people for case ending in 21192.
Matthew Murphy, appearing on behalf of Trenton Greenblaker.
Mr. Murphy, where do we stand with Mr. Greenblaker's cases today?
Your Honor, at this time, in speaking with Ms. Brenner from the Attorney General's office, and then speaking with Mr. Sneed from the Lenawee County Prosecutor's office, it's my understanding that the Attorney General's wish for Mr. Greenblaker to plead as charged with no habitual supplemental status on the child support case. And the prosecution for the Lenawee County, Mr. Sneed agreed that he would plead if Mr. Greenblaker pled as charged to the RNO, that the sentences would run concurrent. So whatever he's sentenced to with the child support case, his RNO would run concurrent with that as well. And obviously, Mr. Greenblaker also has a violation of probation, and he wishes to plead guilty to the violation of probation and take the offer from the prosecution in this matter to plead to the child support case and plead to the RNO with concurrent sentences.
Okay.
Are you aware he still has the domestic violence case pending in district court?
Yes, that's set for trial, and we have a settlement conference coming up on the 24th of April on that one.
Okay.
All right, so if I heard you correctly, he's pleading as charged on all three files, with the agreement being that the sentences will run concurrently.
Yes, that's correct, Your Honor.
Okay. Mr. Greenblaker, would you raise your right hand, please?
Your Honor, could I just clarify my understanding
I'm
of the
sorry.
plea? No, that's okay.
Yes. I'm sorry, go.
I think it's a little different, not much from what Mr. Murphy said, but that he would also plead to that domestic violence. That's part of Mr. Sneed's plea. He
No,
would RNO to the domestic violence, and his sentence would be concurrent with the violation of probation. We didn't say anything as far as the Attorney General case.
Yeah, Mr. Sneed never said that Mr. Greenblaker was going to plead to the domestic violence. That was separate. This was only involving the RNO charge up today, along with the child support charge. And again, I didn't speak with Ms. Brenner about the sentence on the child support. It was Mr. Sneed saying that the RNO would run concurrent with whatever sentence he gets. But again, our agreement was not for him to plead to the domestic violence charge. So at this point, I guess we don't have an agreement unless that's going to be changed this morning.
Well, we generally like to include everything in violations. So if we didn't include the domestic violence, or obviously with this one, then it would, if he's convicted of that, would be another violation, or we can adjourn all of these until there's a resolution with the DV case.
All right, Mr. Murphy, you said you have a trial coming up on the domestic violence case?
Yes, Your Honor. The settlement conference is the 24th of April, and the trial is scheduled for May 5th, I believe.
All right, I can adjourn this to May 10th, which would be the first Wednesday after the trial, if you would like.
Well, Your Honor, I guess we'd ask for that, but I'd also ask if we could address bond on the matter.
All right, go ahead, Mr. Murphy. What do you want to say about bond?
Well, Your Honor, I guess we're in a predicament because Mr. Greenblaker has not pled on the cases. I understand that, with a child support case, there is a large amount that he is in rearage of. the issue that we have obviously with Mr. Greenblaker is that he's not able to earn anything while he's in custody. Now, Mr. Greenblaker understands, I mean, there was a period of time where he didn't report for the probation that he was currently on. That's one of the allegations on his violation of probation. But Mr. Greenblaker understands that he has to address these cases, and that's what he wants to do. And speaking with him over the course of these past few months, he wants to get these things taken care of and move forward. As obviously the R&O incident shows, Mr. Greenblaker is recognizable around the community by law enforcement. He understands that, and he, quite frankly, he knows that if he was not to abide by his bond conditions, he was not to abide by his terms of probation, that he'll be recognized by law enforcement, and he'll be taken into custody. Mr. Greenblaker does not have the means or the motivation to flee the county and completely flee the country and completely avoid all these things. That's not realistic in Mr. Greenblaker's life. Again, he wants to address these things and move forward. He wants to address these cases, accept his responsibility, and try to build a life with these things, again, with addressing these cases and his obligations, and try to earn money to pay his child support. So we're asking if there's some way in which the court would consider giving him a bond, a PR bond that would allow him to start out of custody and try to start getting some income, try to start looking for employment, and try to start earning some income to pay off his obligations and make good on his obligations in regards to child support. So that's what we're asking the court to consider at this time.
Mr. Ianni, anything you would like to say about the issue of bond?
I believe the probation violation is for absconding. Given that history, I think he would be very high risk. Given that we're going to come back in a month, we would object to a PR bond, Your Honor.
Ms. Meir?
Your Honor, I would defer to the court on this. I think there's obviously a statutory bond on Mr. Ianni's case, and I would also leave it to Ms. Walsh to indicate where she's at on the violation of probation.
Judge, just for the record, he has never been employed while he's been on supervision.
Met you.
Mr. Ianni, do you know the amount of the outstanding child support?
As of a few days ago, 31,781.
Sorry, what was that amount?
$31,781.
Looking at the probation violation file, Mr. Greenblaker has already pled guilty once to failing to report, and the current warrant that he has been arrested on is again failing to report. Given that situation, I don't think that PR bond is appropriate. I don't know that he has the means to flee the state or flee the country, but he does not have a decent record of reporting or showing up when and where he's been told to show up. And so I'm not confident that releasing Mr. Greenblaker on a PR bond will ensure his appearance at the next court hearing. So I'm going to deny the request to modify the bond.
Yes, Your Honor. Thank you for taking the time to consider.
All right, Mr. Greenblaker, you can let the officer that's with you know that you're done in court for today.
Your Honor, that's May 10th at 8:15.
Yes, May 10th at 8:15.
Thank you, Judge.
Your Honor, do you want my office to prepare the stipulation in order for that?
Yes, if you would do that, Mr. Murphy, I'd appreciate it.
Yes, Your Honor.
Casey and Kenzie.
What was the date? I'm sorry.
May 10th at 8:15.
And if that offer is going to be made, you just have to have the prosecutor write it out before the next pretrial. But that, okay?
Hello. Yes. We sure do.
Get Casey and McKenzie in one and Wooley, Owens in the other.
And you almost got it.
Thank you.
Good morning, gentlemen at the jail. Can you tell me your name, please?
Malik Owens.
All right, Mr. Solid, you need a breakout session with Mr. Owens?
Yeah.
If he says so, I guess we do.
He just indicated he'd like one, so let me give you a second. I'll set that up.
All right, thank you.
Oh. Have everybody look good.
Why? Because I kept putting on the rooms. Right, gentlemen of the jail, you are Casey McKenzie.
Yes, sir.
Ms. Harrod, you need a breakout session with Mr. McKenzie?
I don't believe so unless he needs to speak to me for some reason.
Yeah, could I?
Okay.
Yeah, 1 second. All right, Ms. Underwood, we have Brandon Huff here. Do you need a breakout session with him?
Yes, please, Your Honor.
Mr. Huff, if you're there, you'll need to unmute your device, please.
Yes.
Okay,
can you-
I'm gonna please. Yep, I can hear you. I'm going to put you in a breakout session with your attorney, Ms. Underwood.
Yes, ma'am. Thank you.
If we have an empty room at the jail, we could take Mr. Wooley.
I'll get him, Your Honor.
Thank you very much. Ms. Muir, do you know anything about Jamie Todd? All right, Mr. Sala, are you ready to proceed with Mr. Owens?
I'd like a breakout room with Ms. Weiss if I could, briefly. I haven't seen her in a while.
Okay, let's see. I think we have Mr. Wooley here, sir. Are you Mr. Wooley?
Yes.
Mr. Murphy, do you need a breakout session with Mr. Wooley?
I don't believe so, Your Honor, unless he wanted to speak with me. I think we're ready to proceed.
Do you want to speak privately to Mr. Murphy, Mr. Wooley?
No, I'm okay. I'm ready to proceed.
Okay. We are on the record in file 23-21329-FH, People versus Javius Tremaine Wooley. We are here today for an arraignment in this matter. We are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Ms. Weir.
Be Weir on behalf of the people.
Matthew Murphy appearing on behalf of Mr. Wooley.
And sir, you are Javius Tremaine Wooley?
Yes, sir.
Mr. Murphy, does Mr. Wooley wish to have the information read?
No, Your Honor, at this time, we're waive a reading of the information. We acknowledge receipt of said information, the witness list and discovery demand from the prosecution in this matter. We're to ask to enter a not guilty plea for Mr. Wooley and set a pretrial in this matter. And I'm asking if we could briefly address bond as well.
Set a pretrial for May 24th. All right, go ahead, Mr. Murphy, if you'd like to address bond, you can do that now.
Yes, Your Honor, thank you. Mr. Wooley has been in custody now, I believe, for over a month. I think this occurred back in March 15th or so. Now, in speaking with Mr. Sneed, from my understanding, the prosecution, we are talking about a plea that would involve Mr. Wooley being placed under the Home Depot Training Act. At least that's, again, the last time I spoke to Mr. Sneed, that's what he was considering. Now, Mr. Wooley, we did try to address bond down in district court. He did end up having an outburst, or he was not following Mr. or Judge Morgan's directions, I believe, in regards to unmuting himself, and Judge Morgan gave Mr. Wooley a contempt. Now, I would ask the court at this time to consider reducing Mr. Wooley's bond down to a PR bond. I don't believe that Mr. Wooley has the financial ability to pay any cash bond at this time, at least definitely not as where it's set at. Now, Mr. Wooley, he does understand that this involves 2 R&O allegations and a domestic violence allegation. So I believe that Mr. Wooley understands the bond conditions and that those will be imposed for the safety of the community. And so I don't believe that further incarceration is necessary to attain that. Also, I don't believe that Mr. Wooley is a flight risk. He understands he has to address these cases. He's recognizable from the police, from my understanding, given the incident. So again, he understands that if he doesn't abide by his bond conditions and doesn't appear in court, if the police recognize him, they will take him into custody. So I don't believe he's a flight risk, Your Honor, given the record in this case. So I'd ask the court to consider a PR bond at this time.
Ms. Weir.
My only request is that he give an address other than the one with Tessa Wooley. Now I understand there maybe either way with other than Tessa Wooley. I think that's on Greenlee Street.
Mr. Wooley's charged with 2 counts of resisting and obstructing and domestic violence. And looking through the file, the probable cause affidavit includes a statement that Mr. Wooley punched a police officer in the face. So There's a strong suggestion that Mr. Wooley is assaultive. And I don't think, given those assaultive actions and the fact that we've got a domestic violence, that I'm comfortable with just a PR bond. Bond at bind over was $3,000 cash or surety. I think that's appropriate under these circumstances. So I'm going to deny the request to modify bond.
Yes, Your Honor.
All right, Mr. Wooley, you can let the officer that's with you know that you are done in court for today.
Okay, thank you.
Thank you, Mr. Wooley. I'll talk to you soon, okay?
All right, thanks, man.
Mr. Saul, are you ready to proceed with Mr. Owens?
I am, Your Honor.
All right, we're on the record then in People versus Malik Antonio Owens, file 20-19882-FH and 22-20974-FC. These are both set for trial conferences this morning. We are proceeding today by video conference. First, let me have the attorneys place their appearances on the record, beginning with Ms. Weiss.
Good morning, Your Honor. Jackie Wise on behalf of the people.
Stan Sala on behalf of Malik Owens, Your Honor.
All right, Mr. Sala, where do we stand with Mr. Owens' cases today?
At this point in time, we are still negotiating possible resolution of the case. We will need a little more time for that. My understanding is, based on the conversation you had with Mr. Daly yesterday, that the trials that are scheduled in your court for next week will be moved. So Mr. Owens' trial is scheduled for the 25th. So it's my understanding that'll be moved.
Where did that understanding come from?
Well, I was under the impression that Mr. Daly was supposed to try a jury trial, so that this case or any other case it's scheduled will be moved, because his is a earlier file number, but I think there's also an earlier file number scheduled the same day as this trial.
Yeah, we have Lucas Crabtree scheduled at the same time, and I've talked to Mr. Glazier, and it's my understanding that's going to go.
All right.
So we asked to just be set for another pretrial and give us an opportunity to potentially resolve this.
Or if the court would rather move it along, we can set it for a jury trial, and Mr. Sal and I can work out something and let the court know.
All right, what I'll do is adjourn it to May, cancel the trial dates, adjourn the pre-trial to May 10th at 8:15 a.m. If we don't have a resolution at that point, I'm going to set it for a new trial date.
Perfect. Thank you, Your Honor.
Thank you, Your Honor.
Okay, Mr. Owens, you can let the officer that's with you know that you're done with court. Ms. Harry, you ready to proceed with Mr. McKenzie? You responded, Ms. Harry, you are mute.
I'm sorry, Judge. What did you say?
Are you ready to proceed with Mr. McKenzie's case?
I am.
All right, we're on the record then in People of the State of Michigan versus Casey Michael McKenzie, file 21-20677-FC. Today's date set for a hearing on a probation violation. We are proceeding today by video conference. Ms. Harrell, would you like to place your appearance on the record?
Yes, Judge. Good morning. Christy Hara on behalf of the defendant.
All right, and where do we stand with Mr. McKenzie's case, Ms. Harrell?
I am still waiting on a final determination from drug court. He was pre-screened and is eligible. I believe they're waiting to see what happens on his felony that he just got bound over on. That matter is set for May 10th at 8:15. So I am asking for an adjournment to have the VOP and his other case consolidated.
All right, May 10th at 8:15 is his arraignment, you said?
He waived his arraignment. He has a pretrial for that date.
Okay. All right, so I'll adjourn this then to May 10th at 8:15 so that those pretrials occur on the same date.
Thank you. If I may briefly address bond.
Go ahead.
So in this case, Mr. McKenzie is being held on a $1,500 cash only bond. Last time we were in court, Your Honor did indicate that if there was a change in his cases downstairs in district court, that Your Honor would review his cash only bond. He did have two pending cases, two felony cases. One was dismissed at preliminary examination, was not bound over. The other one was bound over just recently, but the bond in that file was reduced to only $4,000 cash assurity. So Mr. McKenzie has requested either that he be able to post a smaller cash amount, such as $100, or if he can turn it into a cash assurity. He is indigent, he has a public defender, so he cannot afford a cash only bond.
Judge, this violation is about his absconding and not notifying of his address for months.
He was never charged with absconding, Judge.
That's the violation.
It was a failure to report one time.
He hasn't reported since November 15, 2022. His address is unknown. That's what the
Okay, so-
violation is.
All right, so these are the warrant for probation violation alleges a technical probation violation that he failed to report as instructed on November 15, 2022. He was picked up on the bench warrant on February 15, 2023. Although the warrant only alleges a technical violation, he could also be charged with a non-technical violation for absconding, but that's not happened yet. I think given the circumstances, what I am willing to do is issue a PR bond with a GPS tether. And so that is what I will do. I think I think based on the length of time that he did not report, which was a significant period of time, that something more than a minimal bond is required to ensure that he shows up at his hearings, and I think a GPS tether is the right way to do that. So I will modify his bond so that it's a personal recognizance bond with a GPS tether.
He needs to report to me because he is on probation.
All right, so Mr. McKenzie, if you're released, you need to come directly from the jail to the
I need to see him, to have him come on Tuesday.
All right, so if you're released, you need to report to the probation department on Tuesday at what time, Ms. Holly?
Between 8 and 10.
Yeah.
Tuesday between 8 and 10.
All right. Yes, I really appreciate it. Thank you.
Thank you.
All right. Thank you. Okay. So Ms. Underwood, are you ready to proceed with Mr. Huff?
I am, Your Honor. Thank you.
Clean up my screen a little bit here. Okay, we're on the record then in Brandy Michelle Patterson versus Brandon Dwayne Huff, file 22-49846-PP. We are here today for a hearing on a alleged violation of personal protection order. We are proceeding today by video conference. First, let me have the attorneys place their appearance on the record, beginning with Ms. Meir.
B.B. Meir on behalf of the petitioner in this case.
Rhonda Underwood on behalf of Mr. Huff this morning, Your Honor. Thank you. This is date and time scheduled for a hearing on this matter, Your Honor, but we still have not received the police report regarding the violation. And so we would ask for a brief adjournment so that that can be provided to us. And so.
Okay, Ms. Meir, anything to add?
Your Honor, I did look into this from last time and our office has nothing on this file, including a police report. It was not issued by our office. And I guess it never came to us, so I don't know who would handle that or who can, you know, track that down. I don't even know what agency it is. I think he was arrested on this maybe, and I don't know, honestly. I did request the support staff who handles these to look into it. And I don't know, I guess that's something she wants to talk to me about after court. But at this time, we don't have anything.
Okay, so yeah, this is the one that I've got. I've got the paperwork that we would normally receive when someone is arrested immediately while the PPO is being violated or recently thereafter, but it's not filled out in any way. And other than to have Mr. Huff's name at the top and a case number, and other than that, it doesn't include any details. It's not been signed. There's no way to determine what agency this came from. So I don't, I guess I'll grant Ms. Underwood the adjournment.
Oh, I was gonna say, Your Honor, at this time, do you want to dismiss the violation and let that agency come to us with the violation and we'll issue it if there is a violation? I don't know. I think you heard it upon pickup, so I guess you would know more about it than any of us, but.
Actually, I did not, because that was the week that I was on vacation. So Judge Morgan heard this. And so I think that probably sounds like a reasonable way to go, Ms. Meir, since we at this point, I know nothing about the violation whatsoever.
Yeah, neither do I. So yeah, I'm more comfortable letting them speak on that violation if there is one.
Okay, so what I'm going to do is dismiss this violation, and if the agency that this was reported to wants to proceed with that, or if Ms. Huff wants to proceed with that, I suppose she could report that directly to the prosecutor's office, and
Thank you.
that a proper order to show cause can be issued so that we know what we're talking about.
Thank you, Your Honor.
Okay. Thank you very much. Then, Mr. Huff, you can go ahead and log out.
I believe that concludes my docket this morning, Your Honor.
Rhonda, I had Mr. Lard on, John Lard.
Yeah.
So I don't got to come back to court no more. I'm sorry. I'm just
No, not unless you get any.
Not unless you hear again from the court, Mr. Huff.
Okay. Thank you so much. Have a good one. Bye. Thank you.
The Larde case was adjourned to May 3rd.
Okay.
Violation's over with. Hear me?
Thank you, Your Honor.
And then I did get your note, Ms. Meir, on the Todd case. So I believe we are all set.
Thank you.
Thank you.
Thank you very much. Have a nice day. Mr. Malero, did you still have something?
Judge, I thought we had Brittany Kuhn this morning.
I don't have that on the docket. Do you happen to have a case number?
Maybe. 22-21130 FH.
She is April 26th, so next week.
Oh, she's gonna be relieved because she's been having trouble zooming. So I'll let her know. Thank you, Judge.
Okay, thank you.
Hey, Sam, what about Caden Weir?
Oh, yeah, we got Kate. Didn't we do Kate?
Yeah, we did him.
May 24th.
Thank you.
Sorry, Doug. I forgot.
No problem.
Don't indict me with anything, please.
All right, have a nice day, Mr.